morning. The workshop on ASEAN online dispute resolution will soon commence. Please be seated and mute your mobile phones and other electronic devices. The workshop will be conducted in English with separate channels for simultaneous interpretation and Cantonese and Mandarin. You may pick up your headsets at the entrance of this room. For online participants, you may choose the preferred language as shown on the screen by clicking on the channel directly. You're recommended to use headphones for a better sound experience. There will be 4 panel sessions for today. If you have any questions, please scan the QR code. If you wish to submit your questions, you can type it in the chat box. Besides, for our in-person participants, you can write them down on the paper provided to you on your table. Our staff will collect the questions from you. For online participants, please type your questions in the message box. We'll address them together at the Q&A session. 各位嘉賓，大家早上好。香港法律週2022東盟網上爭議解決工作坊，網上爭議解決可促進東盟及香港企業的跨境貿易和投資即將進行。請大家盡快就座，並且將手提電話調校到震機嘅模式。今日嘅論壇將用英語進行，並設有粵語同普通話嘅即時傳譯。你可以喺會場嘅門口領取即時傳譯耳機。頻道1為英語，頻道2為粵語，頻道3為普通話。線上嘅與會者，請你點擊直播框旁邊嘅語言按鈕，去選擇收聽嘅語言。今日一共有4場嘅專題討論，每一場結束之後都設有問答環節。如果你有任何問題，可以將問題寫低並且交俾我哋嘅工作人員。你亦都可以掃描問答環節嘅二維碼，直接將你嘅問題輸入至問題系統裏邊就可以㗎啦。如果需要任何協助，請舉手，我哋嘅工作人員將為你解答。線上嘅與會者，請直接將你哋嘅問題輸入至問題框、聊天框就可以㗎啦。我哋嘅嘉賓將會喺問答環節去回答大家嘅問題。為咗最佳嘅觀賞效果，我哋建議喺網上收睇直播嘅觀眾可以使用耳機去參與是次嘅活動。多謝。各位來賓，大家早上好。香港法律週2022東盟網上爭議解決工作坊，網上爭議解決可促進東盟及香港企業的跨境貿易和投資即將開始。請大家盡快就座，並把手機調到靜音的模式。今天的論壇將以英語進行，配以粵語及普通話的即時傳譯。你可以在會場的門口領取即時傳譯耳機。頻道1為英語，頻道2為粵語，頻道3為普通話。線上的參與者請點擊直播框旁邊語言的按鈕去選擇收聽的語言。今天我們一共有4場的專題討論，每一場結束後都設有問答環節。如果你有任何問題，可以把問題寫下，然後交給我們的工作人員，或者你可以掃描問答環節的二維碼，直接把你的問題輸入至我們的問題系統就可以。如果需要任何協助，請舉手。我們的工作人員將為您解答。線上的參與者，請直接把你們的問題輸入至聊天框便可以。我們的嘉賓將在問答環節回答大家的問題。為了最佳的觀賞效果，我們建議在網上收看的觀眾可以使用耳機去參與這次的活動。謝謝。 Ladies and gentlemen, our workshop is about to start, so please wait patiently and please be seated. Thank you. Secretary for Justice, Mr. Paul Lam, Deputy Secretary for Justice, Mr. Chung Kok Kwan, distinguished speakers and guests, ladies and gentlemen, good morning. A very warm welcome to the second phase of the workshop on ASEAN Online Dispute Resolution organized by the Department of Justice of the HKSAR government. The theme this year is ODR in facilitating cross-border trade and investment for ASEAN and Hong Kong businesses. A very warm welcome to you all, no matter you are online or in person. My name is Yuki, and I will be your MC for today. So why don't we give ourselves a round of applause? Thank you so much for coming, and it's great to see all of you. Without further ado, may I first invite Secretary for Justice, Mr. Paul Lam, to deliver the opening remarks. SJ, Mr. Paul Lam, please.
Professor Tirado, Consul General, distinguished guests, ladies and gentlemen, good morning. It gives me great pleasure to welcome all of you on behalf of the Government of Hong Kong, in particular the Department of Justice, to the workshop on online dispute resolution today. Building on the success of Phase 1 of the ASEAN workshop on ODR last year, we are organizing Phase 2 of the workshop this year with the theme ODR in facilitating cross-border trade and investment for ASEAN and Hong Kong businesses. With the relaxation of travel restrictions in Hong Kong, we are glad that we have representatives from ASEAN member states, the ASEAN Secretariat, and guests joining us physically in Hong Kong today. The ASEAN has been one of the major trading partners of Hong Kong since the ASEAN-Hong Kong-China Free Trade Agreement and related investment agreement has fully entered into force in February last year. The already very close economic cooperation between us has been further strengthened. In 2021, ASEAN was Hong Kong's second largest trading partner. And despite the pandemic, merchandise trade between Hong Kong and ASEAN last year increased by 21%, reaching a total value of Hong Kong dollar 1,247 billion. Besides, ASEAN was Hong Kong's second largest supplier of goods last year. About 17% of Hong Kong's total imports, more than 900 billion, were sourced from ASEAN. In investment, ASEAN ranked 4th among Hong Kong's destinations for outward direct investment and 6th in inward direct investment at the end of 2020. In particular, over the past few years, e-commerce has expanded remarkably, both within and across the borders. The rapid growth of e-commerce have given micro, small, and medium enterprises, the so-called MSMEs, plenty of opportunities to expand their businesses. It's foreseeable that e-commerce and digital economy will continue to grow and play an important role in post-pandemic recovery and regional integration. Now, with the increase in cross-border trade and investment, it's inevitable that disputes may arise from time to time. In particular, the disruption of the global supply chain caused by the pandemic has given rise to quite a number of cross-border disputes in the past couple of years. An effective means of dispute resolution has become more crucial than ever for cross-border trade and investment. When we are on steady track to recovery from the pandemic, disputes arising from supply chain disruption continue to linger and daunt businesses, especially the MSMEs. In ASEAN, there are a total 70 million MSMEs, accounting for over 97% of the total establishments in ASEAN member states. In order to maintain good cash flow, MSMEs are in desperate need of speedy and cost-efficient means to resolve their disputes. Meanwhile, there's also been an increasing demand for effective mechanisms to resolve disputes involving online cross-border transactions. Owing to the unique nature of these cross-border disputes, it's not geographically or financially feasible or practicable for MSMEs to have these disputes resolved through traditional court litigations or in-person alternative dispute resolution mechanisms. With the help of information and communication technology, online dispute resolution provides a cost-effective and efficient solution to cross-border disputes. As noted in the UNCITRAL technical notes on ODR, ODR can assist the parties in resolving the dispute in a simple, fast, flexible, and secure manner, without the need for physical presence at a meeting or hearing. Through ODR, individuals and MSMEs can utilize technologies in a full spectrum of dispute resolution services conveniently and expeditiously, enhancing their accessibility to justice. With the quick electronic resolution and enforcement of dispute across borders, bridging barriers of different languages and legal jurisdictions, ODR can also provide more confidence for MSMEs to engage in cross-border transactions. And furthermore, by saving MSMEs time and resources in resolving disputes, they can focus more on exploring new business opportunities and expanding their markets. And therefore, ODR is conducive to regional economic growth and development in general. In recent times, ODR has been widely used in various contexts and was promoted regionally and internationally. We can see businesses using ODR as part of their customer services to handle complaints. Courts from different jurisdictions are also exploring how to implement ODR as part of a judicial process to further enhance access to justice. This year, the Asia-Pacific Economic Cooperation, APEC, launched the APEC Collaborative Framework for ODR of cross-border business-to-business dispute, the APEC ODR Framework. and a number of ODL service providers have already been listed under this framework. In addition to the development under APEC, the ASEAN Committee on Consumer Protection launched the ASEAN Guidelines on ODL in April this year as one of the deliverables of the ASEAN Strategic Action Plan on Consumer Protection 2025. The ASEAN Guidelines aims to assist ASEAN member states in setting up or improving their national ODL system to help resolving e-commerce transactions, as well as suggesting proper design and management of an ODL system, with regional and international collaborations, as well as the joint efforts across the governmental sectors, the business sector and the dispute resolution sector and ICT sector. ODL is developing rapidly. Now, in the light of all these developments, Hong Kong has been taking active steps to promote and contribute to the development of ODL in this region and beyond. Hong Kong, China has opted into the APEC ODL framework since 2020. The eBram Center in Hong Kong is one of the listed ODL service providers under the APEC ODL framework, providing comprehensive ODL services equipped with advanced technologies. The Department of Justice has also launched the Inclusive Global Legal Innovation Platform on ODL in collaboration with the United Nations Commission on International Trade Law to keep track of international development of ODL and study various issues on the same. Besides, under the auspices of the Asian African Legal Consultative Organization, ALCO, and with the support from the Central People's Government, the ALCO Hong Kong Regional Arbitration Center was officially opened in May this year. A specific mandate for this ALCO Hong Kong Regional Arbitration Center is to promote the growth and effective functioning of arbitration and other dispute resolution services, including, of course, ODL. All these developments have highlighted the role of Hong Kong in the international development of ODL and the readiness of Hong Kong and our professionals in offering ODL services for ASEAN and Hong Kong businesses, which require an efficient and inexpensive means to resolve their disputes by ODL, as well as for those in need of capacity building for ODL. We look forward to collaborating further with ASEAN on our economic and technical cooperation, particularly in strengthening the ODL capabilities in this region and beyond. Last but not the least, I must thank the ASEAN Secretariat for their continuous support. I hope all of you will enjoy the workshop today with meaningful and insightful presentations and discussions. Thank you very much.
Thank you, Mr. Lam. Please be seated. I'm very sure our participants will enjoy the workshop of today. Up next, may I invite Professor Ignacio Tirado, the Secretary General of the International Institute for the Unification of Private Law, UNIDROIT, to deliver the keynote speech. Professor Tirado, please.
Good morning, everyone. Excellency Secretary for Justice Lam, Excellency Vice Secretary for Justice Choi, dear colleague Professor Zhao, and representative of the Hague Conference, ladies and gentlemen, friends, all of you. It is again an honor to take the floor in this world class event during the week here in Hong Kong. And it is so especially, how can I say, daunting and also a bigger honor to be speaking in a part of the conference which concerns ODR precisely because of where we are. Hong Kong is the center of ODR, is top at what it does. We, during COVID, had the opportunity to actually access some of the examples that Ibrahim very kindly showed us in some of our working groups in Rome, connecting remotely, and we're very much impressed by the work that they were developing. I actually remember 3 years ago, the last time I could come before COVID, that Ibrahim already presented its top work at the moment, and we were all really with our mouths open of how much can be accomplished. And this type of ODR and the type of technology that's provided therein is absolutely key for situations of emergency like the ones we've lived through, but not only. Going forward, I think the development of procedural law will need to necessarily take into account the savings and the improvements that technology can bring in dispute resolution. UNIDROIT, and I'm going to speak about it a little bit, is not an organization which is strictly concerned with the procedural part of dispute resolution, online at least, but rather we are the complement to that. So from this brief speech, I'm going to talk to the other side of the coin, which is exactly complementary to the functioning of ODR. And I should say before I start on the topic that it is particularly important for us, and we're grateful for having been invited to speak in front of the ASEAN community, because it's an opportunity, being as far as we are, that we do not have that often. So we are hopeful that this will be the beginning of a mutual exchange and a fruitful relationship going forward. So let me speak a little bit about our venerable, I wouldn't say old, but rather venerable institution, which is UNIDROIT, an organization which is almost 100 years old, based in Rome, Italy, and which has been working on harmonization and unification of law for almost 10 decades now. It was created in the context of the League of Nations, which was that ephemeris body, the first global attempt at creating a global community of countries that would bring peace. It was in 1926 that this was created, therefore several decades before the United Nations itself, and the spirit of the League of Nations is something which is embedded very much in what we do and what we try to achieve. Our organization has currently 63 member states. You can see there the map, which has too many blank spots in the Asian region, and this is something we would really like to amend going forward. 63 states, however, that account for almost 74% of the world population and over 90% of the GDP. If we consider connected states, therefore those states that have at least ratified one of our instruments, our constituency goes all the way up to 127 states, a very important portion of the world. What we do, as I said before, is work in this setting up of standards to modernize and harmonize private law. And we do that not alone. We do that in an ecosystem of transnational law organizations. And we do this mostly together with our sister organizations, the Hague Conference on Private International Law and the United Nations Commission on International Trade Law. That's why we are called the Three Sisters. And that is a picture of the Three Sisters, a mountain in Australia. I normally need to clarify that part. The work that we do is not ever overlapped, but rather coordinated and in strict cooperation. This is especially evident with our friends and with our sister from The Hague. They do private international law, we do international private law. So it's a perfect complement that we very much enjoy. We do not only work with our two other sisters, we work hand in hand with some of the most relevant law reformers in the world. Many of our work, of our standards are have been adopted and taken to countries by the World Bank, the IFC, the EBRD, the FAO. So this is international financial organizations, but also UN-based entities which work on the ground with countries in legal reform. So the work that we do is taken to those countries directly from these organizations. For example, several of the projects that Professor Veneziano from UNDRA, Deputy Secretary General, will speak about have arisen as a consequence of the petition of the World Bank to do this type of work, because they identified it on the ground, and therefore we came up with the standard. The work we do covers a wide range of private law matters, as you can see: contract law, secure transactions, investment law, access to finance, law and technology, capital markets. Sustainable development is a key part, and I cannot forget, of course, private law and agriculture, which is an area which I believe can prove very important in ASEAN countries because of the size of the agricultural sector in their economy. Agricultural, in part, in some of our instruments, including fishing and including farming and including adjacent parts of it. So let me get a bit to the substance. Let me make a modest proposal here. And I'm borrowing from the famous little book from Jonathan Swift of the 18th century. And the reason why he's cooking some children is that his main theory was obviously a satiric book. When the peoples of Ireland were being sent to Spain in the war of succession between the two different kings, the children in Ireland were dying of starvation because their parents were waging war, so they couldn't feed them. And his modest proposal was to give the children to eat, so the children wouldn't be starving and the parents wouldn't be. So this is obviously a joke and is naturally taken as a proposal which is always daunting and daring, but also clever and witty, because we can't lose the sense of humor even in moments such as this. So this modest proposal that I'm prepared to present to you today concerns the fact that we believe the work of transnational law, and therefore the modernization and harmonization of global transnational standards, actually avoids disputes, and avoids disputes to a large extent. And I'll explain a little bit why and how it does it. And that is where I say we are talking about how to avoid disputes. When disputes are unavoidable and they arise, as they always arise, then we have our ODR to solve them. What transnational law institutions do is they enhance legal certainty. And by enhancing legal certainty, it dramatically reduces transaction costs. By dramatically decreasing transaction costs, what happens is that investment flows. And this is a situation which is much needed these days after COVID, and with some general problems happening in the world which contain and do not allow the flow of exchanges in the world to happen as it used to. Therefore, this is a moment in which increasing legal certainty and lowering transaction costs is especially important. And this is something which transnational law can achieve both domestically and in terms of cross-border. The more clear the law internally, the more modern the law internally, the more the investment will flow, the more lenders will lend, the more entrepreneurs will be active. So this is the idea, and we believe that transnational law plays a key role in this. Further, transnational law, by creating ideal laws in the area of private law, provides for new sources of interpretation, also both internationally and nationally, and that enhances legal certainty again. Obviously, all of this is because it is based on global standards. And you might be thinking, but what are global standards? Who determines what the global standards are? Why is some organization telling me this is the right law to access finance. This is the best model of factoring that you can see. This is the best system of secure transactions or contract law that there is. Well, and therefore, why should we in country A take into consideration these examples? And the answer to that is because of the way it's produced. It is produced in a venue in which all countries participate, countries representatives of the entire world with the different legal families, experts carefully selected to ensure that all the legal families and positions and even different markets are represented and provide their input. So this discussion which takes place in the context of a neutral, technical, transnational law organization is where the discussion takes place. We invite the industry, therefore, and by industry we mean those that apply the law, because otherwise why produce an instrument which those that have to apply it don't like? You need the people who also apply to provide practical input. So it's all that mixed together with absolute political neutrality, with a very high technical level that comes up with rules that are not only technically close to perfect, but are also very, they're apt to be used and applied globally in the different systems. And sometimes you need to adjust here and there, but that's normally the idea. And that is precisely why these type of standards help reduce drastically disputes, both for application or by application of the judiciary in court and also out of court, applying alternative dispute resolution, be it online or in person. So this transnational law, which has different sides, whether you can do it either by means of treaty, obviously, or soft law instruments, and this is something I can already say, soft law ends up being hard law nationally by means of model laws and other types of instruments, is the future of transnational law rather than treaty making, which is progressively becoming more and more difficult to achieve because of the timing. So the world and reality, they move very fast, and treaty making is not fast. It's very difficult, those of you in the room who know about that. So when you are there and you reach an agreement, the reality is no longer that. So you are late already, and many treaties are born outdated. That doesn't happen when you discuss soft law instruments, and therefore it has, it's about access to credit for the use of high-value equipment of different kinds, rail, aircraft, space, or MAC, which means mining, agriculture, and construction equipment. It is our understanding that mining, agriculture, and construction machinery of high value, as well as rail and aircraft, all three, but especially the first, would be of special interest for Asian economies. Let's take the Cape Town Convention example for the aircraft protocol. We are talking about an application of a treaty which has seen more than 1.3, almost now approaching 1.5 million transactions registered in one single registry as existing in Dublin. 1.5 million transactions, and which account for over almost $700 billion in the only concerning the aircraft industry. And that doesn't count the last 2 years where basically no planes were flying. So you can imagine the importance of the instrument. And how do you do this? How do you avoid disputes? How do you make commerce grow? How do you make investment thrive? How do you make planes fly? Well, you do it by simplifying. We all have systems of secure transactions. We all have very different types of pledges, liens, hypothecation, mortgages, all very complicated, each with their own problems. However, what we're saying is, don't do this. Use a functional approach. Have one type of guarantee, we call it international interest, which is described functionally as that type of agreement which goes to secure an obligation of a certain type. One registry in the world, accessible online, 24/7, very cheap to register, for example, an international interest that for a secure transaction over an aircraft, you pay $100. So to register a transaction which embodies more than 3.5 million US dollars, you pay hardly $100. Think about the enormous gain that this gives to commerce. We provide one clear system of priorities, so those that finance the leasing of the transaction concerning an aircraft or rail know ex ante what happens in case the debtor becomes insolvent. And what we do basically is provide also a very efficient system of enforcement in case of default, in case the dispute arises. And when the dispute arises, for example, in rail, these efficient mechanisms go as far as allowing for the unilateral deregistration of the aircraft. What can be more efficient than deregister an aircraft, which means you can't fly, which means you can't have insurance, therefore you can't fly. So there's no need to waste months in trying to get a solution in court. It's a very efficient system. And you might think, yeah, maybe too efficient, isn't it? Because what if there is a dispute, this debtor thinks that this shouldn't be the case? Well, COVID has presented us with an extraordinary opportunity to see how the treaty works. More than 26, the last time we checked, airlines around the world have been in trouble, in financial distress. Obviously, no one can hear in history of such a widespread, simultaneous crisis as that suffered by the aviation industry during COVID times. It was just not possible to fly. Therefore, all the airlines, strong as they may have been in the past, all suffered. And in this case, however, the situation placed those creditors which had claims because they had financed the acquisition of the leasing of aircrafts through leasing companies by the airlines, those creditors were in a very strong position. They could have, because events of default happened, because the airlines were being restructured, could have triggered their ability to repossess the aircraft, could have triggered the possibility to deregister the aircraft. Did they? No. Very, very few cases have happened, and they concerned very small airlines which were non-viable. So why didn't they? Because creditors behave, when they do and they should, in a beneficial, ordinary, orderly way. So it was in their own interest to make sure that they kept their possibility to always be repaid out of the collateral, out of the aircraft. But if the airline is a good business, it made no sense to repossess the aircraft. A leasing company doesn't want to have 20 aircrafts in its warehouse. It prefers that they stay with the airline. So it was a win-win for both parties. So they very intensely contributed to the restructuring of the airlines. So what Cape Town does is avoid dispute by placing strong position in the hands of the creditor, but the creditor, which is a sophisticated institution, makes sure that it only uses the right when it makes sense to do so economically. So in the end, disputes were avoided, airlines were restructured, and there was no need for ODR, at least in this case. For those other places where it didn't happen, there would have been. More examples. I know I'm really about to finish. We have many more. I will not dwell too much on them because Professor Veneziano will detail herself in more detail. But I'd like to mention the work that we do on private law and agriculture, which we think is important for the Asian countries. The contractual schemes, the contract farming schemes will be explained. Our instrument, together with the International Fund for Agricultural Investment, IFAD of the United Nations, is the agricultural land investment contracts. This is a guide which ensures that in case there are investments in land for agricultural use, long-term investments, they are done in a manner in which disputes are tackled and there is fair treatment of all the parties involved. We are doing now work together with FAO, with the Food and Agriculture Organization of the UN, and IFAD again, on sustainability across the supply chain. We are making sure that we analyze in detail not only vertical but also horizontal contractual relationships between the different parts of the supply chain, and we include dispute resolution mechanisms to ensure streamlined movement of goods and assets through the supply chain. This is ongoing work as well. We have some of our signature instruments about to be finalized on model law on factoring, which obviously is key for the development of MSMEs, and SMEs, as the Secretary was mentioning before, absolutely key. The possibility to factor, to access finance with your receivables is of the essence. Even more important for agricultural entrepreneurship, the possibility to access credit by depositing the crops in a warehouse, automatically getting a warehouse receipt, which you can discount and trade on platforms online, so you can access credit directly. All of this done through electronic platforms and in a way in which dispute resolution is ensured. We have the work, of course, on the signature instrument of UNIDROIT, the UNIDROIT Principles for International Commercial Contracts. Together now, we are partnering up with the International Chamber of Commerce to produce clauses and a legal analysis, private law analysis of investment contracts from the side of the UNIDROIT principles. We are, of course, doing a lot of work on the technological side, which is directly related to ODR disputes when they happen. Allow me to mention our work on digital assets and private law, but also the new work we are about to begin on the private law part of voluntary carbon credits, which is also a very important part of sustainable growth and sustainable development. And let me just finish by thanking you for your time and for your patience. And we very much look forward to continuing our collaboration, learning today from all those ODR experts, continuing our collaboration with the government of Hong Kong, and to establishing deep ties with the Asian countries. Thank you.
Thank you, Professor Tirado. Thank you for the stories and application. I'm very sure you have a lot to share. And here comes our first panel session. And the topic is role of ODR in successful conduct of e-commerce and cross-border trade. We're delighted to have Mr. Terence Hui as our moderator. And we have Mr. Michael Dennis, Ms. Laura Aguilera Villalobos, Mr. Benjamin Estetel-Hambel, and Professor Bian Yongmen as our speakers. Mr. Hui is the co-founder and CEO of Prister Corporation Limited. So I will pass the time to Mr. Hui.
Distinguished guests, ladies and gentlemen, good morning and welcome. My name is Terence Hui, CEO of Prister Corporation. Let me start with workshop with expression of gratitude. I'm grateful for the presence of so many of you here today. It's my great honor to be the moderator of section number 1, role of ODR in successful conduct of e-commerce and cross-border trade. In this section, first, we will discuss the importance of ODR system for the trusted development of e-commerce and how ODR platform can benefit MSME, micro, small, and medium enterprise, by expanding their markets and establishing trusted relationship with consumer in the ASEAN region. Second, experience sharing of ODR success and challenges for dispute resolution and consumer redress mechanism in cross-border digital trade. Appreciate the support from distinguished speakers. Michael Dennis, Senior Advisor, the Castle Cake National Law Center, United States. Laura Aguilera Villalobos, Head of the Office of Study and International Affairs, the San Diego Arbitration and Mediation Center. Benjamin Estede Hempel, CEO, Resolution and Linear. They will join both online. Yongmin Bian, Professor and Deputy Dean of the School of Law, University of International Business and Economics, China. Now, may I pass the floor to you, Mike. Thank you.
Thanks very much, Terrence. Good morning, everyone. It's a privilege to be part of such a distinguished panel. Thanks to the Ministry of Justice for inviting me to speak. During my presentation, I'd like to focus on how ODR can assist MSMEs in expanding their markets and establish trusted relationships with consumers in the ASEAN region in cross-border digital trade. There we go. E-commerce has the power to rapidly transform any economy or region. It equals 30% of global gross domestic product. The ASEAN region is the most dynamic region in the world with a fast evolving e-commerce landscape. The region is expected to expand its e-commerce by over 20% in 2022 and is on track to become the fourth largest market by 2030. MSMEs are the engines of economic growth and job creation in all economies. In 2022, 60% of the 5 billion internet users purchased online, creating a cross-border e-commerce market for MSMEs. International e-commerce allows ASEAN MSMEs to build back better after the pandemic, compete and grow by reaching new suppliers, processors, and buyers. An ABEC study found a lack of effective cross-border dispute resolution to be one of the greatest challenges MSMEs face in the digital economy. 58% of respondents cited it as a major or severe problem. In emerging economies, that number rose to 74%. Theoretically, disputes could be handled by the courts. In practice, the courts don't work well for cross-border issues involving the global supply chain and MSMEs. They're too tied to geography, jurisdiction, and in-person enforcement, and cannot cope with cross-border low-value disputes. In fact, the courts already struggle to keep up with offline domestic case volumes. According to the Bank doing business reports on enforcing contract, it took on average 578 days to resolve a simple domestic commercial contract dispute in the ASEAN region at a cost of 43.4% of the claims values. Even if special courts were created or systems were made more efficient, the cost of local counsel, travel cost, plus issues of culture and language means that MSMEs don't have practical access to the courts. All these factors make access to redress a fiction. In-person arbitration is the predominant form of dispute resolution in cross-border trade. Firms like arbitration due to the expertise and neutrality of the decision maker, confidentiality of the proceedings, a lack of familiarity with the courts and laws in foreign countries, and enforceability under the New York Convention. But arbitration is too slow and expensive for e-commerce supply chain disputes. UNCITRAL has developed simplified arbitration rules with a time limit of 6 months for resolving disputes, which is still too long for MSMEs. As a friend of mine said, MSMEs couldn't afford the coffee at most arbitration centers. ASEAN consumers are also affected by the lack of access to justice in cross-border trade. According to the ASEAN study, each unresolved consumer dispute has a cumulative effect on consumer confidence and deters cross-border trade with ASEAN MSMEs. ODR provides a viable remedy for consumers, MSMEs, and lowers the risk for ASEAN MSMEs wishing to enter the transnational digital economy. In July, ASEAN issued guidelines for implementing ODR and is contemplating a regional ODR framework for resolving cross-border commercial disputes. Let's take a look at the international and regional frameworks that already exist for ODR for MSMEs and consumers. The UNCITRAL technical notes on ODR establish basic procedural recommendations or good practices for ODR. Under the UNCITRAL technical notes, ODR technology assists buyers and sellers in resolving disputes in a simple, fast, flexible, and secure manner without needing physical presence at a meeting or hearing. UNCITRAL ODR keeps cost in proportion with the underlying value of the transaction. It allows participants to engage in the process at the time and place best suited to their needs. Under the UNCITRAL ODR technical notes, a technological platform establishes the framework that allows the parties to resolve the dispute electronically. The parties communicate via the ODR platform without the intervention of a neutral person, seamlessly navigating through a myriad of dispute resolution options. The ODR administrator is responsible for process issues, including fairness, due process, transparency, accountability, neutral appointment and selection, and the performance capabilities of the ODR platform. The ODR platform must be highly secure. The UNCITRAL technical notes provide for different stages of the dispute resolution process: negotiation, mediation, and possibly arbitration. The stages act as a funnel, so most disputes are resolved by negotiation or mediation, and only a few cases escalate to an online arbitrator. Studies show that long procedures create dissatisfaction even for the winner. With ODR, negotiation is software-led for speed, efficiency, and cost effectiveness. If no settlement is found, the case may escalate to a neutral, selected from a list of approved neutrals. The neutral delivers online mediation and, if required, online arbitration. The UN General Assembly has endorsed the UNCITRAL ODR technical notes, recommending that all states and other stakeholders use the technical notes in designing and implementing online dispute resolution systems for cross-border commercial transactions. For most e-commerce disputes, ODR is the only practical redress option. The EU ODR platform was implemented in February 2016 to facilitate independent, impartial, transparent, effective, fast, and fair out-of-court resolution of disputes between consumers and traders online. Complaints are submitted via an online form and referred to a national ADR entity that provides online mediation and/or arbitration. In 2020, the EU ODR platform had over 17,000 formal claims, 50% of which were cross-border. Although traders are not required to participate in formal ADR, a few do, about 1% in 2020. Nearly half engage in informal negotiations with consumers on or off the platform. APEC launched the ODR Collaborative Framework in June of this year. The Collaborative Framework is designed to provide quick and affordable dispute resolution and enforcement across borders, languages, and legal jurisdictions to assist APEC businesses, particularly MSMEs and cross-border trade. There are three key elements to the successful operation of the ODR framework. First, economies need to opt in. Second, ODR providers must apply to join the collaborative framework and meet its requirements. And third, MSMEs must agree to use ODR. So far, 5 economies have opted into the collaborative framework: China, Hong Kong, China, Japan, Singapore, and the US. There are no legally binding obligations for an economy. Here you see ODR providers that have partnered with APEC so far. Early results are very promising. The Guangzhou Arbitration Commission takes on average 33 days to resolve domestic and cross-border commercial disputes using the collaborative framework. 60% of disputes are resolved during the negotiation and mediation stages. By comparison, APEC's work on ease of doing business enforcing contracts shows that resolving a contract dispute involving an MSME in an APEC court took on average 440 days at a cost of 1/3 of the value of the claim. ODR is faster than courts by 400 days. It saves time, travel, and lawyer costs for APEC MSMEs. APEC economies and the collaborative framework have a crucial role in promoting ODR to MSMEs and the legal community. Surveys show that microenterprises tend to work without clear contracts and dispute resolution clauses, which leaves them vulnerable in case of a dispute. Widespread adoption of ODR would promote a culture of contract. It would drive down risk and make MSMEs more competitive by lowering cost. ODR brings economic advantages for sellers and buyers in the supply chain. ADR providers can license ODR technology on a case-by-case basis from ODR platform vendors such as Deloitte, ODR.com, and RDO without owning or investing in ODR technology. Several APEC economies have suggested extending the collaborative framework to business-to-consumer B2C disputes. B2C was initially excluded from the collaborative framework because the dispute amounts are small and outcomes are difficult to enforce across borders. And secondly, that consumer laws vary widely within APEC. The APEC rules can accommodate differences in consumer laws. Article 2 of the APEC rules provide that the rules govern unless they're contrary to applicable mandatory laws, such as applicable consumer protection laws. Economies might also be able to overcome enforcement difficulties for consumer awards if the ISO successfully develops an ISO trust mark. The collaborative framework makes special reference to the possible use of trust marks to assist in enforcement. And Yoshi Hayakawa will have more to say on that later today. Before 2020, court systems in ASEAN economies made very little use of ODR. During the COVID-19 pandemic and its associated travel bans and court closings, ODR became essential. Today, elements of ODR have been implemented in almost every ASEAN economy. But courts are still not the answer for consumer needs and cross-border disputes. The Hague Judgment Convention entered into force in September and provides rules for enforcing court judgments across borders. It provides special protection for consumers as the weaker party following EU law. Consumers can only be sued in their own jurisdiction unless they expressly consent to the jurisdiction of another court. But the convention also protects businesses and party autonomy by permitting states to refuse to enforce a judgment against a business if it's contrary to a choice of court or arbitration clause. ASEAN economies that are APEC members are making efforts to promote ODR to their MSMEs and get ready to opt into the collaborative framework. ODR e-justice is essential for economic growth because it fosters the confidence MSMEs need to reach foreign markets. ODR would be a game changer for the millions of small businesses and consumers in the ASEAN region who are without access to commercial justice. It would also facilitate the participation of women-owned businesses in cross-border trade. The APEC ODR collaborative framework and rules represent a unique opportunity to implement ODR in ASEAN economies that are APEC members. For ASEAN economies that are part of APEC, opting into the collaborative framework is essential to enable national MSMEs to expand their consumer base and build back better after the pandemic. APEC ODR principles could also be implemented in the remaining ASEAN economies to effectively expand ODR to the whole ASEAN region. ODR in the ASEAN region can become the cornerstone for the next justice system.
Thank you. Thank you very much, Mike, for the wonderful sharing. And may I pass the floor to Laura and Benjamin, please?
Thank you. Thank you so much. First of all, many thanks again for the invitation to workshop on Ocean and ODR, especially to this session about the role of ODR in successful conduct of e-commerce and cross-border trade. For our institution, CAM Santiago, it's a great pleasure to have the instance to share our experience in online dispute resolution with Benjamin. Let me see if I can change the slide. Sorry, if this is working, I can change the slide. So okay, I'm gonna go forward. I would like to start really briefly giving you some context about who we are and what we do. So the Santiago Arbitration and Mediation Center is a nonprofit institution established in 1992 by Santiago Chambers of Commerce. Our institution has become, on these 30 years of life, a referent leading dispute resolution administration in arbitration, mediation, and dispute boards. During these years, one of the most important pillars of CAM Santiago has been the access to justice, a prompt, efficiently, and easy way to access to justice. And in the path of achieve and have an active role in the legal community, our institution always know that technology is an important tool to be considered in this equation, right? Justice plus technology plus dialogue. Well, in this scenario, technology and justice has become a necessity and crucial tool. We are going to talk about three pillars nowadays crucial in trade and e-commerce, right? Thinking that in cross-border transactions, of course, it could be a conflict, and how we can improve this dispute resolution. Yeah, already Mike gave us some insight about that. In this context, the pandemic and our special case, Chilean social outbreak, accelerate the digitalization of multiple businesses, radically changing whole sector of economy and dramatically modifying our social interactions. The Chilean market is a prime example of the tendency, and in this context, we saw the opportunity to reinforce the link between the justice, technology, as we know, and we work in three important actions. I will be more briefly because I want Benjamin can share with you our developments. In 2019, the center implemented 1,000 online mediators pro bono program to help businesses, especially micro, small, and medium enterprises, to resolve conflict, mainly caused by the breach of contract during 2019, social outbreak, like I said before. And after, with the COVID pandemic, the initiative is founded by Santiago Chambers of Commerce, aimed to support business and the whole community with the free online mediation. Second action is eCam Santiago. One of the main characteristics and our standing assets in what we do and make us special in Latin America is this system, this platform, a modern digital platform for arbitration and mediation process that allow communication, sharing between the parties, arbitration and mediation, intervenient, involved in the cases. And in this 30 years, the history of the center has administrated more. The numbers are more now, 5,000 arbitration cases and 500 mediation cases. And also, we already have 4,500 virtual hearings. That's a good number, considering that everything is online. And the third important pillar for us in like an action for CAM Santiago, it's online dispute resolution development. Like I said before, technology is one of the most important assets. So we work development digital platform in two lines. First, B2B, business to business, and secondly, business to consumer. Like Benjamin is gonna talk to you about that development later. And as a part of a steady strengthening of our institutional presence, CAM Santiago has been cooperating since late 2018 on development of APIC, collaborative framework for online dispute resolution, like Mike said, and on the implementation of ODR, CAM Santiago platform. And after, we are already be part in iGlib, right? Since that time, we initiated the journey become B2B providers, ODR providers. Currently, Camp Santiago B2B ODR platform. It is in a pilot stage, ready for further advances by APEC, and of course, the opt-in of our Chilean government. That this is a really discussion and kind of a thing that we talk all the time with Mike's. So we hope in the future Chile really do the opt-in. And taking further steps in this direction, in 2020, Camp Santiago created its online dispute resolution unit, with the missions is to improve access to justice and provide adequate conflict resolution mechanisms through technology. So now I would like to give the floor to Benjamin, so he can tell you what we've been doing this year in matters of B2C developments. Benjamin.
Thank you, Laura, and good morning, everyone. I'm so honored also to be part of such a great panel and also such a relevant event. As Laura was previously explaining, I have the incredible luck of leading an amazing team of engineers, software developers, specialists like Laura and also I on online dispute resolution, also experts on e-commerce, that developed an online dispute resolution platform that we call Resolución en Línea. That's the Spanish word or phrase for online resolution, that started out as an innovation project inside the Santiago Arbitration and Mediation Center. And now we have spun off of the center this platform to further develop it and even make possible for other institutions to use this same technology. So together with the help from industry experts, the e-commerce committee at our local chamber, the Santiago Chamber of Commerce, and the business community, we built a collaborative platform for helping both merchants and consumers to help them resolve conflicts or problems in e-commerce in a fair, simple, and efficient way. And the way we do it is harnessing the power of algorithm-assisted negotiation mechanism that's been available in e-commerce and marketplace, leading marketplaces such as eBay or Amazon, but weren't previously available for the big mass of e-commerces in Chile and also Latin America or other regions. And in the next slides, we are going to show you how this project has been developing and maybe tell you about this concrete experience as a kind of a case study. So now we have a team that's special inside the Santiago Chamber of Commerce that is developing this platform. He is part of the team that is behind the scenes. And we've achieved some important milestones for us. For example, in 2021, last year, we were recognized as some of the best digital projects by the World Chambers competition of the World Chambers Federation. That's an initiative by the International Chamber of Commerce. And we also reached more than 160 brands, that's e-commerce merchants that are working with the platform right now. We also are working with some of the most distinguished experts in the field. Colin Rule, it's former director for online dispute resolution at eBay and PayPal, a really important voice in the online dispute resolution community, and he's joining us as an advisor from this year on. And we also working in a collaborative agreement with ODR.com. That's an important provider in the United States of America and Canada. So the problem we solve with Resolución en Línea, or this online dispute resolution platform, is the problem of disappointed customers, the problem of clients having a bad experience that not only affects their current relationship with a brand or merchant in the e-commerce, but also that disappointed experience gives way to losing trust in that e-commerce. So everyone here in this room is a consumer. We are all consumers in some time of the day. So with that in mind, it's important to remark that without trust, commerce and e-commerce simply wouldn't exist. And the consumer's first treatment is reaching more importance every day, not only from the dispute resolution side of things, but also from the business side of things. And we now have e-commerce marketplace that are really customer-centric, and that's an opportunity for developing online dispute resolution and alternative dispute resolution with consumers. So the way we propose to solve this problem is developing a collaborative platform that helps merchants and consumers to resolve the problems in a way that is a lot easier than using traditional methods like judiciary or regulatory instances. So our platform is a digital place where we can bring together consumers, merchants, mediators, and also business communities as chambers or business associations to make possible to resolve problems in e-commerce in less than 48 hours, in less than 24 hours in some cases, thanks to the power that algorithm-assisted negotiation has. And the process is based on a first stage where it's really easy for the consumer to find a resolution, because it's the consumer that has a problem, the one that chooses which solution he or she wants for that problem. And that's thanks to a customizable algorithm engine that we developed that is special for every merchant or every e-commerce subscribed to the platform. And when a solution is not agreed by using this dashboard, you can see how a merchant can reach agreements basically in 2 steps. They only need to confirm the solution proposed by the client or the customer, the consumer. And if that doesn't happen and the case needs or asks for a human third party to intervene, you can ask for help of professional mediators. And this works the same as Uber or Didi, as a platform that can use the power of technology to bring together mediators, professional mediators. In this case, we elaborated a list of mediators specialized in consumer cases together with the Mediators Association and the Santiago Arbitration and Mediation Center. And these mediators can start working the case in totally online. We've had a great traction thanks to our close work with the e-commerce committee at our local chamber. We now work with more than 160 brands, from big brands with global presence like Under Armour or Samsung and Philips that choose to subscribe to the platform in a self-regulation and good practices scheme. But also we are helping small entrepreneurs, small e-commerce to digitalize and jump on board this digital revolution, transforming their customer service channels with online dispute resolution that's completely stored in the cloud. more than 70% of cases are settled with an agreement thanks to this technology, and more than half of the cases are solved via an agreement in less than 48 hours, with 98% of that agreements reached by assisted negotiation without resourcing to the intervention of a human third party. So, what's the benefits for the merchants? And with this, I'm closing the presentation. It's saving time, money, is reducing cost of resolving conflicts, is protecting the brand reputation, having a next level customer experience, and also building trust. And all of this is possible thanks to a software as a service operational model that is really a novelty in online dispute resolution services. And every merchant that subscribes to the platform has a trust mark that identifies these merchants as a merchant that's compromised with the fair treatment of their consumers. So that's the story that we wanted to share with you. Just a remark that we have the chance to transform justice together, and this digital revolution that we can bring together to justice is a really concrete way of doing e-commerce grow, and also facilitating investments all across the Asian region, but also across the world. So many thanks for your attention.
Thank you very much for the insightful sharing from Laura and Benjamin. Now, may I invite the last speaker of the section number 1, Professor Bien. Professor, please.
Thank you, Chair. Thank you very much. Good morning, everyone. I'm very honored to join today's workshop to share with you the experience of Chinese e-commerce platform in ODR for cross-border trade. So let me see. Okay. First, e-commerce is very important for Chinese economy, especially under the pandemic. E-commerce contributes 38.6% of Chinese GDP in 2020. I take Alibaba as an example. From April 2021 to March 2020, the annual global merchandise turnover of Alibaba Group reached $135 billion, of which $9.65 billion is from international commerce, up 25% year on year. Here I use the exchange rate of last year between the US dollars and the Chinese renminbi. If you use the exchange rate today, the value in US dollars will be a little bit smaller than the above figures. By March 31, 2022, Alibaba Group's global annual active consumers reached about approximately 1.3 billion. In 2021, the gross merchandise value of Alibaba ranked first in the world. Alibaba has two e-commerce platforms, one for B2C transaction and one for B2B transaction. On my PPT on the left side, you see on the top one is the B2C, and the third one, 1688.com, is for B2B. And most businessmen on Alibaba's B2B platform are sellers, benefit from China's various manufacturers, a so-called factory of the world, Alibaba was able to design a giant e-commerce platform to serve millions of Chinese sellers for B2B and B2C transactions. Why is ODR important for small and medium entities to engage in cross-border transactions? The small and medium entities may never meet each other before they sign a contract. Why do they trust each other? I think their trust comes from a rule-based e-commerce platform, which will assist transboundary dispute settlement in case their transaction has a trouble. ODR is a core part of this online transaction rules. When Alibaba started its e-commerce platform, China had no online transaction rules or ODR. Parties had the rights, and today they still have the right to submit their disputes to traditional dispute resolution, such as court litigation or formal arbitration. However, with those choices available, parties choose to use ODR because ODR has great merits over traditional disputes resolution. First, I think ODR is very efficient and convenient. Normally, a dispute via ODR can be solved within just a few days, which is not possible if you go to the court for litigation. Alibaba's ODR is guided by AI system in the initial stage. The AI system, based on historical cases of contractual disputes, identifies and categorizes the problems and the claims corresponding to each problem. The applicant, often the buyer, initiated the ODR by clicking on the problems and the claim of his transaction. The AI will send this complaint to the seller immediately. Then the mutual negotiation started. According to Alibaba staff that I interviewed, 80% of complaints were settled by mutual negotiation facilitated by AI. The settlements are motivated by the following credit system and the payment guarantee, which I will explain soon. If either party is not satisfied with the facilitation of AI, he can press the button to ask for human intervene. And second, e-commerce platform may create its own carrot and sticks to drive ODR. Alibaba has developed a system of penalty points to punish merchants who do not settle disputes seriously. The punishment is merchants' future trading opportunities at Alibaba platform. Since many merchants have operated their business on Alibaba for many years and have built up good reputations, they certainly want to keep their commercial credits. The merchants who did not solve their disputes with clients will get penalty points. Parties will first be warned if they get up to 12 penalty points, and their trading rights may be suspended for 7 days if they get up to 24 penalty points. And the next, if their trading rights might be suspended for 15 days or 30 days if they get more penalty points. And in the worst case, the merchants may be forced to close his shop on the Alibaba's e-commerce platform. In addition to the above credit or penalty point system, there is also a payment guarantee system to work for the ODR. On the Alibaba's e-commerce platform, the seller won't get the money from the buyer directly. The money was paid to a third financial service institution of Alibaba. After the buyer received and accepted the goods, the money will be transferred to the seller. So if the buyer made a complaint immediately after receiving the goods, the seller won't get the money easily. So the seller has to engage the buyer for dispute resolution. And here is a very simple chart to show you the process of ODR and Alibaba's platform. I take the example of a case raised by a buyer because most complaints initiated by buyers. After the buyer raised a complaint, a negotiation started between the buyer and the seller. And if they reach an agreement, the e-commerce platform will facilitate the enforcement of the agreement. And if they failed in mutual negotiation, the Alibaba will intervene at the request of either party. After party presence evidence, Alibaba will make a decision and will enforce that decision. And for the enforcement, and first, the traditional way of enforcement by court is available if parties so choose. The party always have the right to submit the dispute to the court, including traditional court or internet court. China now have 3 internet courts located respectively in Hangzhou, Beijing, and Guangzhou. The second, e-commerce platform like Alibaba has the capacity to enforce the resolution reached by ODR. Alibaba has strong enforcement of the conciliation reached by Alibaba, by the Alibaba ODR system. The winning party may get compensation from the platform first. Certain sellers with good reputation and integrity record can get a credit approved by Alibaba. The seller may use that credit to get finance to pay the buyer immediately after the conciliation. In case the payments of the buyer have not yet been transferred to the seller, those money will be refunded back to the buyer very soon. In addition, the e-commerce platform also facilitated the enforcement of court judgments. The e-commerce platform can enforce the court judgment by the disposal of properties belong to the losing party but holding by Alibaba. In addition to dispute resolution, e-commerce platform also developed some trust mark to mitigate disputes. There are 2 kinds of trust marks of Alibaba works very well. First, on the left side of this PPT, the top one is a trust mark of gold sellers, which is a trust mark for commercial integrity. Sellers with this mark are qualified to get loan from the platform to pay compensation to buyers. The second trust mark, that's the bottom one on the left side of the PPT, is the trust mark for those sellers who have committed to pay consumers according to Alibaba rules. So for the buyers of B2B or the buyers of B2C, and they look at these different trust marks to make their transaction decisions. what can we learn from Alibaba? I think, as other presentators already talked, and ODR is very crucial for MSEs to engage in online e-commerce. And AI is very helpful in ODR. And 80% of the disputes was settled with the help of AI. And AI, including standard operation procedure of Alibaba, will help to identify the issue and recommend solutions. And the AI will also contact the liable party automatically and repeatedly to address the problem. And the AI has no bias to either party and can be very neutral and is able to work with multi languages. And next, reputable traders are very reasonable and cooperate in resolving disputes because they cherish their reputation and future trading opportunities. And trust mark designed properly can facilitate the enforcement of ODR. Actually, Alibaba also designed some trust mark for consumers because the Chinese law has some special protection to consumers, and some this special protection cannot be enjoyed by professional businessmen, and some professional businessmen want to hide their identification and try to claim those consumer protections. So the system, the platform is able to trace the different transactions and to identify the problematic consumers. Last, I want to say to work with e-commerce platform may make MSEs stronger because the platform not only provide trading opportunity, but also endorse the commercial credit of the traders, provide guarantee for the implementation of the contracts and ODR. Thank you very much.
Thank you. Thank you very much for the wonderful sharing from Professor Bien. After all this professional advice and sharing, here with some questions from our audience. As we are a bit running out of time, so we have one question. From your observation, do customers trust those MSME which use ODR system more as compared with those MSME not having ODR system? May I have a mic to take this question?
Certainly, and that's really a great question, and that really is what goes to the heart of what we're talking about. What we're trying to develop here is ODR systems that work across the board to build trust between MSMEs and consumers. Right now, I would have to say we've looked and we've seen that the courts don't really work as far as cross-border disputes are concerned. It doesn't work really to sign up business after a dispute arises. If you look at the EU ODR platform. Another option is the collaborative framework, but it's excluding business-to-consumer transactions right now. So yes, I think that that consumers right now would look to platforms like Alibaba, Amazon, eBay to resolve disputes. I think also the CAM Santiago model is fantastic. It works really well as far as domestic disputes are concerned. I think there's other similar platforms like that that I've seen as far as Parle in Quebec has a similar operation, and perhaps it doesn't resolve disputes as fast, but it does resolve a high percentage of disputes. So I think having ODR is essential. to build consumer trust. And I think that consumers will go where they know that they can resolve the disputes through ODR. And right now that's on the platforms and platforms like Com Santiago. Thanks.
Thanks, Mike. Thanks. What about Laura and Benjamin? Any special views? Or we could have Professor Bien. Yeah.
Oh, can I?
Yes, please.
Okay. For me, as a consumer, I certainly will choose to use the e-commerce platform with ODR as a future dispute resolution. This option is very important for me because I actually don't know the seller or the trader. I trust the e-commerce platform, and I also trust the ODI. Just if something happens and I can get some remedy, certainly a transaction with ODI is preferential for me.
Thank you. Thank you. Okay. Once again, thanks for all the fantastic sharing from all the speakers about ODR. Before ending our section, let's give a round of applause to all the speakers. Thank you very much.
Thank you, Mr. Hu. Thank you. Please stay because we have a photo-taking session. So thank you, Mr. Hu, Mr. Dennis, Ms. Aguilera Villalobos, Mr. Acetal Hambel, and Professor Ben for the very informative session. So please stay and please look at our camera. For our online speakers, you can look at your own camera. And for Mr. Hu, you can look at our photographer because this is something that's very unique. So you can prepare your smiles, make sure you give a bright one. All right, so I can count 3, 2, 1. All right, 3, 2, 1. Thank you very much. One more, I think, at the back. Yep. Thank you so much. And Mr. Hu, please take a seat. And thank you, our online speakers. We know we are in different time zones, so please take a rest if you are in the Europe time zone. So before we move to the second panel session, we will have a break. And our second session will begin at 11:50 Hong Kong time. So please take your valuable belongings with you whenever you leave this hall. Please enjoy the refreshments in the designated areas outside this conference room and return to this conference room by 11:50. For our online participants, there's no need to log out. Thank you very much. Ladies and gentlemen, we are about to start, so do take a seat. Thank you. Ladies and gentlemen, welcome back. The topic of our second panel session is International Instruments for Contract Enforcement and ODR. It's going to explore the role of international legal instruments and international dispute resolution enforcement framework and ODR. We're pleased to have Mr. Edward Liu, MH, as our moderator, Professor Anna Veneziano, Mr. Jieshong Li, online, which is Professor Zhao Yun as speaker. Mr. Liu is the partner of Haiwen and Partners LLP, so I'll pass the time to them. Thank you so much.
Thank you, MC. And good morning, ladies and gentlemen. Welcome to the second session of today's workshop. As the MC just mentioned, I'm Edward Liu, the moderator of today's panel, with this distinguished guests here and also online. I hope you had an enjoyable session this morning on the conduct of the e-commerce and cross-border trade. As the MC just mentioned, this session will focus more on the international instrument for contract enforcement and the ODR, the online dispute resolution. So we have heard a lot this morning about the growth in trade, especially through regional e-commerce. But as a dispute resolution lawyer, from my perspective, it would also lead inevitably to more cross-boundary disputes. So traditional means of resolving disputes by cross-boundary litigation, from my point of view, is not really a good option for micro, small, and medium-sized enterprises who often face actually the financial constraints in hiring legal representations and struggle to survive in the lengthy court procedure. So staggering legal and traveling costs, coupled with language and cultural barriers, these all would pose great difficulties for traders to obtain access to justice through domestic courts. And therefore, I think there's a pressing need to provide traders with an avenue to obtain access to justice in a time-efficient and cost-effective manner. And this is the role of play by the ODR. Yet, we all agree probably that effectively resolving the disputes not only require a convenient and good revenue to resolve it, but also it requires a uniform set of rules for the commercial parties to easily enforce the for example, like the arbitral awards or the settlement agreement. And therefore, we all know that we have, for example, the new convention for arbitration, the Singapore Convention for mediation, and the HCCH convention for judgment for the civil and commercial judgments. So today, as we have heard several times from the day one of this week, that we have very privileged to have the three sisters of the private international law organizations appearing in Hong Kong. And for my session, especially that I have the representative from these three organizations, and we will hear from them, from their perspective, organizations' views about the international instrument on the contract enforcement from the ODR perspective. Without overdue, let me first invite Professor Anna Veneziano, the Deputy Secretary of the UNIDROIT, to give us the first share. She will be giving us an overview on how UNIDROIT instrument strengthens the contract enforcement. Thank you.
Thank you very much, Mr. Chair, and distinguished delegates, ladies and gentlemen. It is an honor and a privilege to speak again at the Legal Week, and particularly at this workshop on ASEAN online dispute resolution on behalf of UNIDROIT. And I wish to thank the Department of Justice for the invitation and ASEAN for co-organizing this workshop and inviting us to participate. Now, as you have heard from our distinguished chair, and I would like to thank him particularly for the preparation of this workshop, I will particularly focus on contract enforcement and international instruments helping and facilitating contract enforcement, also with a view to preventing dispute resolution or facilitating dispute resolutions. And it is clear why contract enforcement and international instruments in this area are important, because a well-functioning legal framework for contractual enforcement, maximizing the value of the contractual relationship. We know that contract enforcement plays a role in preventing commercial disputes, and I would like to give some examples on that. International instruments may help setting shared and accepted legal rules that improve the effectiveness in cross-border situations, and generally speaking, they help protect parties' rights and access to justice. Now, as the Secretary General of UNIDROIT has already underlined in the keynote speech, UNIDROIT has developed a number of instruments on contract enforcement, both cross-border through the introduction of harmonized rules, and at domestic law level as a guidance for legislative reform. And some of these instruments look at contractual enforcement from the perspective of drafting and enforcing contracts. And therefore, we have the UNIDROIT principles on international commercial contracts that were already mentioned by the Secretary General, as well as the work we have done on contractual agricultural production under contract, and particularly the contract farming guide. We have instruments, again, from the contractual side, strengthening creditors' rights in financing transactions. The Cape Town Convention is an excellent example. But we also have instruments that look at contractual enforcement from the side of substantive procedural law. And here I will only mention the ALI UNIDROIT principles on transnational civil procedure, which were developed with the aim of facilitating transnational disputes, and the more recent adaptation of these rules to the European environment. And I mentioned these rules because even if they are limited to Europe, they contain very interesting elements pointing to the importance of case management and mediation even within a dispute resolution in front of a court. And then we have an ongoing project which deals specifically with contract enforcement, with the execution phase of the rights of the creditor, which is of immense importance and sometimes overlooked by international organizations. So I will focus only on 3 of these instruments, trying to keep within the allotted time. And in particular, I would like to start with the UNIDROIT principles of international commercial contracts. As some of you may know, this is a non-binding set of principles and rules which cover the most important aspects of general contract and obligation law. So it's not a treaty, it's not legislation, though they have influenced legislation, and we know that they played a role in giving models for reform, even recent reforms like the Chinese Civil Code, the French Civil Code. But they are essentially a soft law instrument. So they are based, their authority, let's say, is based on extensive comparative law studies carried out over many decades. They have been prepared by a group of truly international experts that came from all continents, and they have been translated in a number of languages, including, for example, Chinese or Vietnamese. Now, it's a neutral, balanced, and practice-oriented set of rules because of the participation of these experts, and the attention to the practice of commercial law is of high technical quality. I have put the links to the English version, but also to the Chinese black letter rules for your information. And so, how are these principles usually applied? They are applied because of their persuasive value. So they are an additional opportunities, a tool in the hands of parties of a transaction, because they're a tool for party autonomy, but they're also a tool for adjudicators, be they mediators, be they actual adjudicators like arbitrators or even courts. And their other characteristic, which I think it's important for solving a contractual dispute, is that they are particularly versatile. So they have been used and can be used in a variety of ways. And this is a list as guidelines for drafting international contracts, chosen by the parties as the law governing the contract when the domestic law so allows, or in the context of arbitration, as content of their contract, as guidelines to reach settlement agreements, which is quite an important practical way the UNIDROIT principles have been used, but also as a tool for adjudicators in the situation where parties have expressly chosen them, or when parties refer to more general principles of international commercial law, just to give more concrete value to these principles, or when parties did not choose any applicable law and it was clear they meant to exclude the application of any specific domestic law. And finally, a very important way the principles have been applied in practice is even by domestic judges, as a kind of background law to help solving some issues of interpretation of domestic law, particularly involving international commercial contracts. But I would like to go rapidly to the next, to the next slide, because wrapping up on the UNIDROIT principles, how do those principles strengthen contractual enforcement and prevent disputes? Because they provide an internationally accepted restatement of international contract law, which has a good balance of parties' rights and obligations, they can help parties find a suitable applicable law to an international contract in all the situations where there is no agreement on the application of a domestic law. Of course, if parties prefer to apply a domestic law, that will be possible. They can help parties and adjudicators reach or propose a settlement agreement in case of disputes, and they can help arbitrators solve disputes when parties have, as I said, referred to general principles of commercial law. They finally can help interpret domestic law when there is a gap, which might be the case for legal systems that have not adopted recent civil codes, for example, and they can help judges in finding a solution in case of conflicting interpretations within domestic law, if they want to apply a solution which is more suited to international commercial disputes. Now, I would like to very rapidly come to a second instrument which was developed by UNIDROIT, which might be particularly interesting in this context, both because of the ASEAN context and because of the fact that this is a particular contract, the relationship between an agricultural producer and a buyer, many times an international buyer. Now, this is part of UNIDROIT's work on private law in agriculture, which has been developed, as the Secretary General said, in cooperation with FAO and IFAD, and it's a result of a cooperative endeavor, because we had a working group, and one of the members of the working group was an Indonesian expert, but we also had the representatives of farmers, agribusiness representatives, and we had extensive consultations, including consultation in Asia, particularly in Bangkok, and later on discussions of this guide in Indonesia and with representatives, for example, from the Philippines. Now, what is contract farming? Very rapidly, is an intermediate form of coordination and connection between production and international markets. There is an agreement prior to production on the commodity, on the price, and the buyer generally provides support for the production. So it's a very relational contract. And what are the potential benefits and risks? The benefits are that there is a secured output market for the farmer and a stabilized income. There are mitigated production risks for the parties, but also for access to the products for the agribusiness. There is a conformity to product quality and safety standards. Generally speaking, this is conducive to more food security, but there are also risks. And what are the risks? This relationship can be asymmetrical, can impose unfair contractual conditions and fraudulent practice, particularly on the farmer. So the guide focuses particularly on the contract between the producer and the contractor and follows the development of this contract. And the parts of the guide that might be particularly interesting for this workshop are those dealing with remedies for breach and on dispute resolution. Why? Because, first of all, the guide focuses on reaching a fair and enforceable agreement in application of basic principles, fair and loyal dealings, transparency, cooperation between parties, because it's a relational contract, effective and proportional remedies, but specifically fair settlement of problems arising during performance. So we can see this particularly in the parts on remedies for a breach, excuses for non-performance in case, for example, of supervening events, which are particularly important in the agricultural sector, and dispute resolution, with the highlight of the importance of mediation and alternative dispute resolution methods for solving these particular disputes, with participation, for example, of representatives of the different parties. Now, I have a very limited time at disposal, and therefore I will only mention one of the ongoing projects of UNIDROIT, and I'll be, of course, at your disposal if you have any additional questions or curiosities about it. It's the project on best practices for effective enforcement, which we started because of a request of the World Bank. And the idea is that while effective enforcement of creditors' claim is actually an essential part of the legal framework for a developed credit market, it's actually very important also for a sustainable development and economic development. It's part of full access to justice. There is a growing concern in many legal systems about inefficient enforcement systems, and we know this is true in, of course, some of the ASEAN legal system, but also many other legal systems in the world. And therefore, there was a need to provide global standards in a practice-oriented manner. And one of the ways we are working in order to provide these legal standards is to integrate technology into the enforcement proceedings, including judicial proceedings. And this is why, for example, we refer to online dispute resolution as a possible solution for solving even disputes within the phase of enforcement and execution. And we also look at other ways technology can, and platforms and sharing of information can help enforcement of decisions, but also self-help enforcement in situations like, for example, security rights. So I will stop here just to say that it is a project which is ongoing, expected completion in 2024, but we do envision a consultation phase, so we will be very happy to exchange with you and know whether you are interested in this subject and to continue the discussion. I hope I kept more or less within the time. Thank you very much for your attention.
Thank you very much. Thank you very much indeed, Anna. It's very good, very thanks for your good sharing. And when I was listening actually to your speech, I was very excited to know that the great efforts taken by UNIDROIT. And also, I think to express our gratitude is that we participate in the consultation to help UNIDROIT to make the to further go on to unify the international codes and rules for the contracts. So next speaker is Professor Zhao Yun, who is a representative of the Regional Office for Asia and the Pacific of the Hague Conference on Private International Law. And Professor Zhao will give us an overview on ODR from the HCCH perspective, including the international regulatory efforts, its enforcement mechanism, and the pending issues. Professor Zhao, please. Thank you.
Thank you, Chair. Ladies and gentlemen, it is a great honor for me to speak on this very important occasion. I still have fond memories of my participation in the ASEAN ODR workshop in the previous years. And I have a lot of discussions regarding the cooperation between Hong Kong and ASEAN in the field of ODR. So today I'm very pleased to talk about the issues more from the HCCH perspective. My colleagues have already mentioned about a very important role of the UNIDROIT. For me, I think probably I will look more from the enforcement stage, the final result. How can we enforce the final result? So basically, I will first of all introduce to the ODR very briefly and examine international regulatory efforts in concluding relevant international instruments. I will then talk about the enforcement mechanism for ODR and look into pending issues on how to facilitate the enforcement of the ODR results. Cross-border trade and investment, very important topic, very hot topic, were facilitated with the emergence of the internet. I still remember in 1995, we have a lot of discussion about e-commerce. Now, with the extensive use of technology in business transactions and fast development and expansion of e-commerce, there's an urgent need to have ODR, which can help to resolve disputes effectively and efficiently than traditional dispute resolution mechanism. We are not talking about the traditional dispute resolution, the usefulness, or whether we still need to look into how to come up with new instruments. We are now looking into the ODR. How can we make full use of the ODR in a new era? It was noticed that ODR developed slowly in the first few years. However, COVID-19 provides an excellent opportunity for the adoption and acceptance of the ODR by the public. With the difficulties in travel and arranging physical hearings, the ODR was the only and right choice for the disputing parties. For example, in April 2020, the Hong Kong government announced the establishment of the COVID-19 ODR scheme under the Anti-Epidemic Fund to provide speedy and cost-effective ODR services to the general public and businesses. In particular, as SJ mentioned, MSMEs, which really needs the ODR. Under the scheme, parties will attempt to resolve their disputes through a multi-tiered dispute resolution mechanism comprising negotiation, mediation, and arbitration. The ODR will not end even after the pandemic. It is a future, an irreversible change in the field of dispute resolution. It provides an extra choice for the disputing parties. Given its advantages in saving cost and time, the efficiency and the effectiveness of the ODR will definitely be very helpful for the public in choosing ODR for the resolution of their disputes, in particular for low-value disputes and also for MSMEs. For the success of ODR, it is very important to have a healthy regulatory environment. I'm very happy to see in the past few years a lot of achievements have been made. Here in this slide, I listed several documents, which, of course, our first speaker also have identified the very important documents, the Unidroit principle. We know that an effective ODR platform must be supported by an appropriate legal framework and an effective IT infrastructure in order to facilitate the dispute resolution processes and ensure smooth enforcement of the outcome. As a result, most of the existing ODR services have the resources to provide the necessary support, including resources to tackle issues on platform accessibility, privacy and confidentiality, communication problem. So for example, the online dispute resolution platform can provide the use of various languages. And also, we will also look into the governance and oversight of the operation of the platform and the enforceability of the outcome of the resolution process. In other words, the ODR outcome can be enforceable and final and binding to the parties with the support of the public entities and appropriate legal instruments. In order to have a better understanding of the ODR enforcement mechanism, we should first of all examine existing legal instruments that ODR can rely upon during the enforcement processes. My colleagues have already some discussions regarding the Unidroit documents, and I understand the next speaker will focus on the ancestral documents. So I will basically focus on the HCCH documents, which is the HCCH 2019 Judgment Convention. The Judgment Convention provides legal certainty and predictability to parties involved in cross-border transactions, providing clarity as to whether and to what extent a judgment will be recognized and enforced in another jurisdiction. By ensuring the recognition and enforcement of foreign judgments, this convention enhances access to justice by reducing legal timeframes, costs, and risks in cross-border circumstances. with the conclusion of the HCCH Judgments Convention, we have a full picture regarding the enforcement regime, which is the 1958 New York Convention for the Recognition and Enforcement of Foreign Arbitral Awards, the Singapore Mediation Convention for the Enforcement of Foreign Settlement Agreements, and the HCCH Convention for the Recognition and Enforcement of Foreign Judgments. When it comes to the ODR, more specifically, I should mention at least the following two instruments, as the speaker, Mr. Michael Dennis, have mentioned in the first panel. The 2016 Ancestral Technical Notes on ODR and the APEC Collaborative Framework for ODR both have been making efforts in providing regulatory guidance for ODR. I should also mention that the HCCH Tourist and Visitors ODR project, which try to look into the use of ODR to resolve cross-border tourism disputes. The development of a guide may provide useful assistance to tourists and visitors in pursuing claims, such as providing factual information to assist tourists and visitors in assessing which ODR platform may suit their needs. With the support of international instruments, it will be good to examine enforcement mechanism in ODR. The existing ODR enforcement mechanism can be roughly divided into two categories, namely private enforcement and court-enforced mechanism. The private ODR enforcement mechanism can be further divided into automatic execution, incentive-driven enforcement, and self-enforcement mechanism. Automatic execution can include the chargeback model and the escrow account model, which functions just like the credit cards. When it comes to the incentive-driven enforcement, something like the rating system and trust mark, which are indicators of trust, the difference being the former is user-generated and the latter is institutionally generated. Professor Bian in our first panel also touched upon this issue regarding the Taobao Alibaba model. A trust mark has been used very widely, and I believe this will continue to play a very important role. The third category, the self-enforcement mechanism, has been increasingly important. If we look back to the 1998, 1999, it's rather important to look at the domain name dispute resolution mechanism, which has always been considered to be one of the most successful ODR mechanism. We basically rely on the platform itself to help to resolve the disputes instead of relying on the external entities, including the court. Here, successful examples can include Alibaba public jury and Taobao staff mediation, etc., which rely on secure transactions and irrevocable authorization through Alipay. Court-enforced mechanism is not something new, relying on traditional court enforcement. As such, the three international conventions shall play an essential role in ensuring the recognition and enforcement of decisions made by the third neutral party. The court-enforced mechanism provides judicial control over the legality and fairness of ODR outcome using a set of legal rules stipulated in the international conventions and domestic laws. Compared to private enforcement, the due process control of the ODR decisions is much more strict and much more clarified in a court-enforced mechanism. However, it takes more time and money for the party to seek court-enforced mechanism than private enforcement. To strengthen enforcement, we will need to seriously consider several issues. First, a trustworthy decentralized system. The self-enforcement of ODR can take advantages of blockchain technology and smart contract to boost the efficiency of the enforcement process. The e-currency or blockchain-based system will often criticized as a trustless alternative to existing financial institutions and even government. The increase in confidence and trust in the decentralized system ultimately relies on the proper operation and governance of the underlying blockchain-based network, which requires the support of local government and unified international standards for cross-border applications. Secondly, regulatory regime for cross-border ODR is rather important. I have just mentioned about some very important efforts that have been made as a UNCITRAL, the United Nations Commission on International Trade Law, and also APEC platforms. Now we will need to continue to see what kind of a platform can be set up for example, B2C or C2C disputes. I believe that an appropriate regulatory framework is very important in resolving international commercial disputes in a relatively predictable manner, which will in turn facilitate the adoption of ODR by the public. This will also enhance the enforceability and legal certainty of ODR outcomes. Thirdly, domestic legislation. While international instruments are important, domestic legislation is also needed to ensure certainty and efficiency. For example, domestic legislation should provide clear provisions on valid formalities of e-signature, particularly in a context of cross-border online transactions. I believe that a lot needs to be done to improve, to further strengthen the enforcement of ODR outcomes. But we are very happy to see that a lot have been done, and we will know what will be the next to move forward. The APEC has done a great job for the B2B disputes for MSMEs. Now, what will be the next step? That's something we will need to look into. So with this, I conclude my presentation. Thank you very much.
Thank you, Professor Zhao. It's a very good speech for us to, I think, give us the very in-depth views about how, especially the mechanism for the enforcement being done by HACCH and also the other organizations. And also, I think the pending issues would leave us a very good topics for the next year workshop that we can collaborate more in details. So we have heard so far the UNIDROIT and also HACCH's sharings about their organization's efforts in unifying the mechanisms for the international instruments for contract enforcement and ODR. So last speaker today is Mr. Jason Lee, who is a senior legal officer of UNCITRAL. And he is also currently working as a secretary for the Working Group 3 on Investor-State Dispute Settlement Reform. But sadly that he cannot be with us today and will be discussing with us ODR from the UNCITRAL perspective through a video recording. So let's have a look.
Good late morning, early afternoon, everyone. As introduced, my name is Jae-Sung Lee, and it would have been lovely to join the two panelists, Anna and Yoon, and the distinguished moderator, Edward, in person. But I had to take an earlier flight out of Hong Kong, which requires me to make this recording. My sincere apologies. Let me start by drawing your attention to a recent discussion in UNCITRAL's Working Group 2, which had prepared the Singapore Convention on Mediation, and more recently, the UNCITRAL Expedited Arbitration. Now, the working group embarked on a new project this fall, last month, to explore a new type of dispute resolution method, which could address the needs of the tech and other industries to have a very quick resolution of their disputes, which is shorter than the 6 months time frame provided for in the UNCITRAL Expedited Arbitration. But also, we incorporate certain elements of adjudication, more often used in the construction industry. In adjudication, a decision is rendered by a third-party expert, in a short time frame, while the parties retain the possibility to pursue arbitration or a court proceeding after the project is completed. The discussions thus far led to a possible development of a two-phase process whereby the decision in the first phase would be made by a decision maker. Now, we're intentionally avoiding the term arbitrator because it might be or it might not be an arbitrator, but that is to be rendered in a very short time frame, and the dispute is subject to a full-fledged arbitration afterwards, if the parties so wish. Now, during that debate, two questions arose. How can one ensure that the first phase decision is complied with by the disputing parties? And if not, how would the first phase decision be enforceable, both domestically and across borders? With regard to the first question on compliance, one idea was that the disputing party should not be allowed to refer the dispute to arbitration unless it has complied with the first phase decision. So only after the losing party makes payment in accordance with the decision would it then be able to pursue arbitration. While this would ensure quick compliance, the question arises whether the parties can agree to such a pre-arbitration contractual arrangement which limits or conditions the right to refer to a dispute to arbitration or possibly a court proceedings. Furthermore, it is not clear whether decisions involving a wide range of disputes, for example, a tech dispute involving IP issues, will also always be straightforward, making it possible to easily determine whether a party had complied with that decision or not. The second question follows the first one. If the losing party does not comply with the first phase decision, can the winning party enforce the decision, and how? On this point, the discussions evolved around how to benefit from the existing enforcement mechanisms for arbitration, the New York Convention. One suggestion was that the first phase decision should also be made within the framework of arbitration, so that it is kind of characterized as a preliminary or an interim award, which would be rendered by an arbitrator in a short time frame, yet subject to a full-fledged arbitration by the same or different arbitrator if one of the parties so wishes to raise it to the next stage. Another suggestion was that a decision by a non-arbitrator decision maker, so it's not a non-arbitrator, in the first phase could eventually be transformed into an award which would allow the parties to benefit from the New York Convention and domestic laws based on the UNCITRAL model law on international commercial arbitration. So the idea was to use what's already out there, the existing mechanism, rather than reinventing the wheel. You may be wondering where I'm going with this, but the ODR proposal poses similar issues as the first phase decision-making that I just referred to. So let me now address the topic of this panel, contract enforcement and ODR. Currently, there is no cross-border enforcement mechanism for contracts, and one would have to go through a cumbersome judicial process to have contracts enforced. And of course, the applicable law issue poses another set of issues, whereby the CISG prepared by UNCITRAL provides a solution for at least contracts for the sale of goods. In principle, cross-border enforcement of contracts rely heavily on voluntary compliance by the parties. However, there is a cross-border enforcement mechanism in place for the outcome of dispute resolution processes. In other words, a settlement agreement under the Singapore Convention, an arbitral award under the New York Convention, and a judgment under the Hague Judgments Convention. These regimes, these cross-border regimes, enforce the results of the proceedings, but not the contract itself. And in order to do so, certain conditions have to be met. And in addition, there are safeguards in place allowing courts to refuse enforcement, for example, as provided for in Article 5 of the New York Convention and Article 5 in the Singapore Convention on Mediation. So when it comes to ODR and its outcome, the same question that Working Group 2 is pondering about arises. Can the outcome of an ODR benefit from the existing legal frameworks for cross-border enforcement? In other words, does ODR result in an award, a settlement agreement, or judgment? If so, do those existing frameworks, which rely on domestic court proceedings, mostly requiring in-person participation and which takes much time, go hand in hand with the ODR process, which should be remote and quite quick. Shouldn't there be a different mechanism to ensure that the parties comply with the outcome of the ODR process and to ensure cross-border enforcement? UNCITRAL had previously worked on the topic of ODR, defined broadly as mechanisms for resolving disputes through the use of electronic communications and other information and communication technology. As such, it encompasses a broad range of approaches and forms, as well as the potential for hybrid approaches, which kind of introduces both online and offline elements. In 2010, with a sharp increase in online cross-border transactions, which have become more so evident, and the need for a mechanism to resolve disputes arising therefrom, UNCITRAL initiated the ODR project, and the genesis of that project was quite sound. Traditional judicial mechanisms do not offer an adequate solution for cross-border e-commerce disputes. And one solution was ODR, which can assist the parties in resolving the dispute in a simple, fast, flexible, and secure manner. That work resulted in the 2016 Technical Notes on ODR, a rather short text after a quite lengthy 6-year discussion, which illustrates how it is sometimes very difficult to achieve legal harmonization. This difficulty partly resulted from the fact that the project had a broad scope to cover disputes arising out of cross-border, low-value sales or service contracts, both in the B2B, so business-to-business context, but also business-to-consumer context. The technical notes mention some key principles of ODR: impartiality, independence, efficiency, effectiveness, due process and fairness, accountability, and transparency. But as a technical note, it is a descriptive text in nature and does not have the status as the UNCITRAL arbitration rules or the mediation rules, whereby the parties can actually refer to it. Now, as to the different stages of the ODR proceedings, the note mentions negotiation as the first stage, facilitated settlement involving a neutral as the second stage, but leaves the third stage unidentified. This is because whether arbitration could be mentioned as the final stage, particularly for business-to-consumer disputes, was heavily debated in the working group. While the technical notes may not be the most shining legislative product of UNCITRAL, as Mike Dennis probably mentioned in session 1, they form the basis for APEC to prepare the collaborative framework for ODR for cross-border business-to-business disputes, so it's narrow in scope, as well as the model procedural rules. As the UNCITRAL technical notes do not provide for a final stage, it also does not address the issue of compliance or enforceability. And this brings me back to the issues I raised earlier. I would caution against too much focusing on the enforcement of the ODR outcome. Rather, I would emphasize that this enforceability at the end of the process is what ensures compliance by the parties of the contract and of any decisions rendered through an ODR process. ODR should be understood as a tool to ensure that the parties comply with their contractual obligations, and if they don't comply, or if there's a dispute about the performance or decisions rendered through the ODR process, if there's a dispute about the performance of the compliance, ODR should provide a quick solution so that the parties can go about their normal business. In most cases, parties would comply with the decisions voluntarily rendered through the ODR process. This is particularly so if they have trust in the ODR system and they feel that they were treated fairly and were given the opportunity to present a case. Nonetheless, in light of the quick decision-making in the ODR process and the most likely remote nature of the ODR process, I do wonder whether the same standard of due process and fairness as required in the traditional dispute resolution mechanisms should apply equally to ODR. And I would pose this question to the audience as well as the fellow panelists. The following question: could some aspects be sacrificed to achieve a more timely and cost-effective resolution of the dispute? As most of you know, UNCITRAL is an intergovernmental body with the mandate to progressively harmonize and modernize international trade law. In a sense, it is a legislative body with focus on developing and preparing international legal norms. The recent development in the use of technology in dispute resolution, further fueled by the pandemic, has resulted in various calls for work by UNCITRAL in this area. The question, however, is so what kind of norms do we prepare, on which aspects, and for what purpose, with the underlying question, would it be desirable or feasible to develop an international legal standard? Considering the broad range of issues that have been identified so far, the Secretariat has started to use a more generic phrase to refer to all of this dispute resolution in the digital economy, DRDE, to capture all such issues. This is because a number of different ideas are floating around as to possible future work. Some are talking about the use of technology in the traditional way of resolving disputes, remote hearings, electronic evidence, and documents. Some are referring to online platforms, which I'll refer to later. Some are referring to disputes that are new in the digital economy, such as those arising from data transactions, crypto disputes, including where the disputing parties may be anonymous. And some are referring to disputes that arise from the use of technology or disputes in the tech industry. So in that context, UNCITRAL is taking a broader perspective and has requested the Secretariat to take stock of, so compile, analyze, and share information about developments in DRD, taking into account the disruptive aspects of digitization. There is quite some emphasis that the stock-taking should focus on ways to preserve the fundamental principles of dispute resolution, including due process and fairness, but also enhance the efficiency of the proceedings, both of which would build the confidence of the users. One aspect that the stock-taking project will examine is the use of online platforms, more generally and for dispute resolutions. Online platforms, referred to also as digital, electronic, or e-commerce platforms, are being increasingly used in international trade. While online platforms generally provide for the sale of goods and supply of services, they employ a range of technologies and offer a number of additional services. Some of the e-commerce platforms have inbuilt systems for handling complaints and settling disputes arising from activities on the platform, while dedicated ODR platforms offer dispute resolution as their main service. In this respect, I'm happy to note that UNCITRAL is cooperating closely with the Hong Kong Department of Justice on these areas via the Inclusive Global Legal Innovation Platform on Online Dispute Resolution, the acronym being IGLIP on ODR, which is a joint initiative between the Hong Kong Project Office for collaboration with UNCITRAL and the UNCITRAL Secretariat. So IGLIP on ODR aims to keep track of recent developments in ODR and to identify possible future work in the area. Composed of 26 experts from around the world with different legal traditions, the most recent meeting addressed the need for an international legal instrument on access to justice and the role of ODR, and considered the possible scope, providing for a forum of exchange, and some minimum core standards to be embodied therein. Having been reported of these developments, the Commission this summer endorsed the continued cooperations, and the Secretariat looks forward to closely cooperating with the Hong Kong Department of Justice and the experts on this front. With that, I hope I have given you an overview of UNCITRAL's existing work on these subjects and what's expected to come. Thank you for your attention, and feel free to contact me or UNCITRAL at any time should you have any questions. Thank you very much.
Great. Let's thank Jay for the very good presentation. And I think, well, we still have, 3 minutes. And let's try to, actually there are quite a few questions raised by the participants. But before that, remember that actually Jay in his speech raised a question, I think, to the audience, but I would like to ask both of you first. I think he mentioned that in view of the quick decision-making process and the very likely remote nature of the ODR process, whether the same standard of deal-making process and fairness as required in the traditional ADR mechanism should also apply equally to the ODR. Any views? Probably Anna first, and then Professor Zhao. Yeah.
Thank you. It's a difficult question, but I would like to answer it by looking at the work we are doing on general enforcement and execution of creditors' rights, because this is exactly the challenge that we have, looking at both at traditional execution methods, but how to render them less costly, more rapid, and therefore more effective, on the one hand, by preserving, however, on the other hand, the fundamental rights to be heard and to raise opposition on the part of the debtor. It is a challenge, and one of the avenues we are exploring is to look at the situations where legal systems allow for extrajudicial enforcement and try to see how to facilitate in those cases the solution of possible disputes through the use of technology, by encompassing in the technology the possibility to raise complaints and to solve them. And this is very similar to what should happen in ODR.
Yeah, sure, definitely. And Professor Zhao.
Thank you. First of all, I think when it comes to the ODR, I think today we are talking about the online negotiation, online mediation, and online arbitration. I think that's something I think probably I need to qualify. We are not really talking about online litigation, etc. So now, when it comes to these areas of the ODR, we probably talking about the due process. In the traditional dispute resolution field, we do emphasize about the importance of the due process, which can win the trust and confidence from the users. Now, if we are encouraging people to use the ODR, we need to make sure that all the technical aspects can satisfy the needs of the public and to win their trust and confidence. In various areas, we notice that some kind of a digital gap. When we mention about the digital gap, that means there are two levels of meanings. One level meaning basically country A, country B, they are not at the same technologically developed level, so they probably have some digital gap. The other type of digital gap is that some people might be easier to adapt to the digital environment. So in a way, we have to take into account all these elements and try to consider what kind of a technological elements or factors or systems can be provided to those in need. But again, I think the basic elements of the due process and natural justice should be realized. In what way? With the assistance of the IT. I think that would be most important.
Yes, thank you. And indeed, it's a difficult question, but I think both of you give a very crystal answers that the due process is also necessary for the ODR. To conclude our panel, I'd like to ask both of you the final question. Very briefly, give me just 1 or 2 sentence answer. What do you think are Hong Kong's advantages in developing ODR, especially from the perspective of facilitating the trading and the transactions in ASEAN region? So just 1 or 2 sentences, probably that's more difficult, but yeah. Anna.
Thank you. Well, we actually had the possibility to be helped and be informed during the development of our enforcement project by, for example, to mention one, Abram. They participated virtually to our discussion in order to show how execution and enforcement of claims can be done through technology. And therefore, from this, we can understand that Hong Kong is a hub for this kind of thing. So we cannot but think that this should be promoted. Thanks.
Thank you, Anna. Professor Zhao.
Thank you. I think we, in a way, should be proud of ourselves in Hong Kong. Hong Kong is not only the center for dispute resolution, but also a technology center. In a way, we can combine the technology and dispute resolution. If we take EBRAM, I think as SJ has mentioned this morning, I think I understand the CEO of EBRAM will also speak this afternoon. I would say that this is a vivid example regarding the access to justice or access to digital justice in various ways. From the very beginning, we are not only talking about the ODR platform for dispute resolution, we are also talking about the ODR platform, which can help you to facilitate the deal-making process and then help you to monitor the contract enforcement to dispute resolution and finally to the enforcement of the final result. So thank you.
Yes, thank you. Thank you very much indeed again for your good sharing, and also thank you for your kind attention. Let's all conclude our panel discussion, and let's wait for the afternoon session. So thank you very much indeed. Thank you.
Thank you. Thank you, Mr. Liu. And speakers, please stay on stage for a group photo. Yes, please smile. All right, wonderful. Please take a seat. Thank you so much. Dear distinguished guests, speakers, physical and online participants, thank you for your support of the workshop on ASEAN online dispute resolution. This is the end of the morning session, and our afternoon session of the workshop will begin at 2 p.m. Hong Kong time. Please be seated 5 minutes before 2 p.m. For our speakers, moderators, and invited guests, please proceed to room N206, which is opposite to this room. For online participants who are applying for CPD points, please kindly join us with the online link on time at 2 p.m. So we will see each other again at 2 p.m. Thank you very much and enjoy your lunch. Thank you.